You may be surprised a little bit that I'm not talking about specific M&A issues, but rather address the issue of confidentiality from an arbitrator's perspective. Because, by the way, the wrap-up or a summary of my presentation can be found in the conference brochure. Let me shortly explain what it means. I've been appointed as an arbitrator, as chairman of an arbitrary tribunal, and I have my two co-chairmen sitting there, and we look forward to ruling and discussing an M&A issue. And suddenly, or after having discussed the case beyond ourselves, we have the feeling something is wrong about this case. We either hear about financial transactions that seem to be not quite kosher, or we learn that some crimes or offenses might be involved. It could even happen that we, as the arbitrators, have the impression that the entire litigious arbitration proceedings are a fake only. A fake only why? Because they are conducted for the purpose of creating a mock transaction, a mock fight about the facts of the case. We may have the feeling that the parties want the arbitration court to render an arbitration award, which later then can be used as a legitimate basis for certain transactions, for instance, for a payment of $1 billion US. That could otherwise be considered as money laundering or antitrust arrangements. In other words, they want to have an arbitration award or an arbitral settlement to create an artificial basis for a payment, for instance, corruption. So you sit there as an arbitrator and say, hey, they want to misuse me. What can we do in such a situation? Are we allowed to engage in such a transaction, in such an arbitration at all? And if so, are we bound by the duty of secrecy and confidentiality? Because parties usually go to arbitration because they want to keep their things secret. Can I do that and agree to be misused? So what I will do now, and I promise I will be short because I'm the last speaker for today, I just want to summarize the duties of confidentiality of arbitrators, the limitations of such duty, and whether or not an arbitration court must forego or may relinquish confidentiality. The legal relationship between the parties and the arbitrators is defined by the arbitration agreement. We heard that several times today. So it's generally accepted that an arbitration agreement establishes a duty of confidentiality for the arbitrators, even if it does not contain express confidentiality provisions. The general view is that the duty of confidentiality serves the interest of the parties. When they conduct arbitration proceedings, they often disclose very confidential information to the arbitrators. However, if the duty of confidentiality would only protect the parties, then the parties would be free to release the arbitrators from this duty of confidentiality. This is not acceptable because the arbitrators also have to comply with the duty of confidentiality vis-à-vis their respective co-arbitrators, the party-appointed arbitrators. And then also the secrecy of deliberations, the discussions between the members of the arbitral tribunal constitutes the element of confidentiality among the arbitrators. This is an essential procedural principle, and the independence of the arbitral tribunal is guaranteed only if the deliberations are kept secret. Thus, the secrecy of deliberations does not only protect the parties, but also constitutes a right of each and every arbitrator. It cannot be waived by the arbitrators. So, let's have a look at the procedural rules When national arbitration rules apply, the duty of confidentiality of an arbitrator follows those rules, for instance, the German Institution of Arbitration, the Swiss rules of arbitrations, the rules of the Arbitration Institute of the Stockholm Chamber of Commerce, the DIFC LCA rules. In all of these rules, confidentiality is addressed. Much to my surprise, the ICC rules of arbitration do not contain confidentiality provisions. Only their annexes contain such a provision, and all this suggests that the ICC rules solely oblige employees of the ICC, but not the arbitrators, to confidentiality. That's a surprise. And the Vienna rules do not provide at all for any duty of confidentiality. Arbitrators are subject to the duty of confidentiality not only with respect to the content and the course of the deliberations, but as regards all circumstances and facts that they learn or know during the arbitration. It's even inadmissible to interrogate an arbitrator as a witness as to the course of the deliberations. In state jurisdiction, filing an appeal usually causes the relevant court of appeal to consult and inspect the files of the respective lower court. In arbitration proceedings, however, there is no appellate arbitration panel. In Germany, arbitral awards can be challenged before the competent higher regional court, Oberlandesgericht, which then decides on the reversal or the enforcement of an arbitration award. Thus, the question is, does the higher regional court have the right to ask the arbitral tribunal to submit its files, or is the secrecy of deliberations of the arbitrators contrary to this idea? In contrast to state court proceedings, a review of the arbitration proceedings by the higher regional court does not constitute a continuation of the arbitration proceedings. Neither the parties nor the higher regional court have a right to inspect the files of the arbitral tribunal. And by the way, what are the files of the tribunal? Is it the files of the chairman? But now, back to the question of what arbitrators should do when they discover that the arbitration is a mock case. When must confidentiality be relinquished? Does the occurrence of offenses in arbitration proceedings establish an obligation of the arbitrators to disclose these offenses to state authorities, to the public prosecutor? As anyone else, arbitrators are subject to the general obligation to report imminent, serious crimes. Under German law, for example, crimes considered serious enough are, for example, murder or robbery or an endangerment of peace, the planning of a war for the country. In minor cases, such as the cases of money laundering or cartel arrangement or corruption, arbitrators are not per se obliged to report to the law enforcement agency. It is clear that an obligation of arbitrators under public law to make a statement cannot at the same time be qualified as a violation of their duty of confidentiality. However, it is assumed that in such a situation, arbitrators are obliged to at least make use of their right to refuse testimony to the extent possible and refer to the secrecy of deliberations. Now, we learned that the arbitrators are not obliged, but may they relinquish confidentiality? It could be assumed that the termination of the mandate as an arbitrator also terminates the arbitrator's duty of confidentiality. If one follows that view, it would easily be possible for the other arbitrators, the parties and interested parties, third parties, to fully inspect the arbitral files after the termination of the arbitral proceedings. Arbitrators, referring to their duty of confidentiality, could not refuse the inspection of the files once arbitration is over. This obviously is a wrong view. Confidentiality, of course, remains even after conclusion of the proceedings. Absent the case of imminent serious crimes, arbitrators are not obliged to notify law enforcement authorities of criminal law facts. However, they may have the right to do so. There is a widespread discussion pending in which cases such right to notify exists and what at the same time implies an abandonment of the duty of confidentiality. Both the rejection of the right to notify and the acceptance of such right to notify are considered legally valid options. So I cannot give you a definite answer. It's alleged, for instance, that arbitrators are not prevented from notifying the competent authorities if they suspect the future commission of a crime or money laundering. With that, I leave you. Thank you very much.